So today we're going to have like a basic estate planning webinar slash seminar. We're going to talk about some techniques to make life easier for yourself and your loved ones. Um, some of you may have seen some of this before in a previous webinar or previous in-person meeting. Not sure, because I think some of you might have been attended some of these in the past. So we do offer an initial consultation, no charge for everybody. Um, if you meet with me, everything you tell me is confidential, and we have an attorney-client relationship when we do that. So let's go to the first slide. We'll talk about who's involved in that estate planning process. So if you come in to meet with me, we'll talk to you. You're our client, obviously, and we have that attorney-client relationship, as I mentioned. And you want to do this during your lifetime, obviously. It's very hard for us to do planning after you're deceased. So it's nice to meet with you during your lifetime. There's very little post-death planning that can be done by anybody. When we meet, we talk about how you want your estate distributed. And when I refer to estate, I'm referring to like a generic concept of assets. Think of it that way. I know a lot of us think of an estate like in the financial institution realm, that it's something opened at the courthouse, and I do refer to it that way when there is, quote, an estate. That means an estate is perhaps open for somebody, but we also use the word estate just as a general term for your assets in general. So we talk about how you want your assets distributed. Do you want them distributed over time? Do you want them held in some kind of trust? Things like that. We talk about how you're going to handle your creditors with your estate, because creditors can file claims against your assets or against an estate that's open in the courthouse. If you have a trust, uh, different than a quote estate, sometimes we can avoid creditors and not pay certain unsecured creditors with a trust. And most importantly is that last topic, your family and heirs, because that's what this focus is on, is your family, your heirs, your beneficiaries, people that you want to be protected or taken care of when you pass away. So let's talk about some testamentary planning. You're going to hear me use two concepts today. One is testamentary planning, which is planning for death. That's death planning. And the other is going to be some lifetime planning. So testamentary planning is what we do. The traditional kind of planning that we plan for how we're going to distribute assets after you're deceased. We can go one more slide, Tasha. So we call that the post-death planning. That's what we're planning for now to distribute assets on death. So the most common method of that is something called a last will and testament, or we refer to as a will generically. And you all have seen wills probably, or you know what wills are, and we're going to talk about those. Another way is with a trust agreement. And what a trust agreement does is it creates a private probate or a private distribution, the same thing that a will does. But again, it does it with outside of a will, outside of the probate process, and it does it privately. We'll talk about that. And some other planning techniques are to jointly title assets with your loved ones, add somebody to the deed to your house, add somebody to your car title. Sometimes those are good techniques. Most of the time they're not. We'll talk about that too, why they're not. And lastly, there's something called a pay on death designation. That's something that you can add to your bank account at Nimio and any other financial institution in Maryland and in other states as well. So you can add a beneficiary or an heir so that the asset is distributed directly to them on death. Okay. So let's talk about if you don't have a will or you don't have anything in place. We use this strange word called intestacy or called intestate. So if you die without a will or a trust, then you die what we call intestate. We have a statute in Maryland that governs how distributions are made for people that die intestate. It can be a little complicated if you have minor children because you don't have anybody designated in a will to raise those children or care for them or provide for them. So then the court is heavily involved and the court is going to appoint a guardian for them. And it's not going to be a stranger. Don't be alarmed with that. It'll be some family member. but sometimes we get involved in custody fights among relatives. I've over the years been involved in several custody battles in the court system over grandparents fighting for who's going to raise the grandchildren when both parents are deceased. If there are no relatives, then obviously foster home is a possibility, and that's a remote possibility, but that can happen. And what we have to remember is that minor children are, quote, minors when they're under the age of 18, and they're adults at age 18. So if you die without a will, and the court is involved, they're going to appoint a guardian to hold that money. But at age 18, the children can access the money and get to the money. And whereas if you had a will or a trust, you might not want your children to get the money at age 18. You might want them to not get it until they're 25 or 30. But that doesn't happen. If you die intestate at 18, they get the money. So dying intestate has a great deal of court involvement. As I said, the guardians have to follow a lot of court procedures. Courts are involved to a great extent. And what does that mean? Lawyers, right? So what do lawyers mean? Fees. So you can avoid some of that if you have a will, because now you have people designated in your will about who is going to be the guardian for your minor children, who's going to raise them, who's going to be in control of their money. You don't have to have any court involvement if you do that with a will. So that's an important reason not to die intestate. And it's kind of an urban legend that if you die intestate, the state gets your money. That does not happen. Some people think that their estate as cheats to the state of Maryland if you die without a will. That is absolutely not true. It's just that probate process, that process to get your assets distributed to your heirs, is a little more complex or complicated when you die intestate. Great. Thanks, Tasha. So this is kind of a summary of what our statute says if you die without a will. So we're going to talk about who gets assets here if you die without a will. So on that top box, let's say in Maryland, if you're married, your spouse will receive your assets if you die without a will. That's what our statute says. If you also have children and you're married, then one half of your estate goes to your spouse and the other half to your children. Okay? And if you're not married, everything goes to your children. So, and then after that it would go to parents. So let's pretend that you don't have a spouse, you don't have any children, you don't have any parents. Well, next it goes to your siblings. Okay, so your siblings would receive your assets. And if you don't have any siblings, then it goes over to your grandparents. If you don't have any grandparents, we're getting to what I call the laughing heirs. Those are going to be aunts, uncles, and cousins. And I call them laughing heirs because they're laughing all the way to the bank with your money, because you may not know them that well. You might have met them 10 years ago or 20 years ago or something, but you don't stay in touch with them maybe. They're probably not your first choice of who's going to receive your assets. And that's why I call them the laughing heirs. And then it goes to great grandparents. And then ultimately, if we can't find anybody, then your assets could escheat to the state of Maryland. They could go to the state of Maryland. Rarely does that happen. I've had it happen once in my practice where we couldn't find an heir for somebody. We had to turn it over to the state. So what are the issues with dying intestate, right? So the laughing heirs, they could possibly inherit your estate, your assets, and your personal representative can be somebody you don't know. So personal representative is somebody you name in your will, you list their name, and an alternate usually as well. And that's somebody who's in charge of your estate. So that's the person who's responsible to make certain filings with the Register of Wills office and to, quote, walk you through the estate process. And that process in Maryland takes a minimum of 6 months. The estate has to be open for 6 months for creditors to file a claim. And your personal representative is the person in charge of that. But if you don't have a will, your personal representative can actually be a creditor. And that's a strange concept. In fact, NIMEO and other financial institutions can be personal representatives. And creditors like to be a personal representative because they can have more control over your assets than they do as just a creditor. For example, a lender that might have a mortgage loan in default because you've died and nobody's making your mortgage payments, let's say, that mortgage company can come in and petition to be your personal representative. And in that role, they can take charge of all of the assets that you had and have or had, including your home. They can list it for sale with a realtor and sell it, and it's an easier fix for them than to foreclose on your property. So we often find mortgage companies coming in and acting as creditors in estates. As I mentioned before, it's a possibility that if you don't have heirs out there, your assets could escheat to the state of Maryland. So, how do we make these distributions if you don't have a will and you don't make a choice? We can't. There's nothing we can do because again, this is all statutorily governed, and the statute directs who receives these assets if you die intestate. So we can go one more slide. So by creating a will or a trust, then you can make choices and you can designate these individuals that I mentioned that are missing if you die intestate. You can designate who you want to receive your assets. It doesn't have to be a laughing heir, right? It can be somebody you like or somebody you love, somebody you want to receive your assets. It can be a charity, it can be anything you want. And when you have your will, you can also designate your personal representative. That's again that person who is in charge of your estate and managing it and then ultimately making distributions. And in some states, we call that person an executor. You may have heard that term as well. You can designate those guardians for your minor children, as I mentioned. That way, you don't have any custody fights among the grandparents. You can also designate a trustee to manage the money. That doesn't have to necessarily be the person who's raising your child or children. So you can designate one person to be the guardian of the children, and you can designate somebody else to be the money manager, to be in charge of the money for them. So when we meet and talk with you, we talk to you about who would you like to have these roles. Obviously, people that you trust, relatives, friends, people that you have confidence in that would watch out for your children's best interests and your best interests as well. So your estate is everything that you own that you have an ownership interest in when you die. It can be your personal property, your things, your car, your furniture, your belongings, your jewelry, your personal effects. That's what we call personal property. It can be any bank accounts that you have, investment accounts. You may own a business or have an ownership interest in a business. It can be your real estate as well, your real property, we call that. So we look to where that property is located. Sometimes it's all in the state of Maryland. I have many people who pass away owning property in other jurisdictions or other states. And we call that an ancillary probate. You may have a home somewhere else. So we probate your assets here in Maryland. We go through that probate process. And then we might have an ancillary or a small probate in another state. We also provide you something called a personal property memorandum with your will or with a trust. That's like a document that supplements your will and it designates who you want to receive certain items. You might have a family heirloom, a grandfather clock, or a watch, or some other, a car that's special to you that you want your grandson to receive, or you want your cousin to receive, or something like that. You don't have to list that in your will, and you can list that on your personal property memo. We give you that too. It's kind of neat. Your will makes a reference that you might create this document in the future. So it's incorporated into your will, but you actually fill out on the personal property memo in your own handwriting. We call that holographically when it's in your own handwriting. You fill in that document holographically. So let's talk about ways to distribute assets. I touched on this briefly early on. So one, you don't necessarily have to have a will to distribute assets on death, right? You can own an asset with somebody. Many people have bank accounts with somebody else on them, a spouse or partner or friend. So if it's a joint bank account, um, that account is going to pass directly to the survivor when you die. Another method is to title assets in the name of your heirs. Not necessarily a good thing to do. There are some tax consequences for this and also some creditor consequences. So let's pretend that own a piece of real estate in my own name. Let's pretend I'm single and I decide to add my child to that deed with me. So let's say I add one of my children. I have two, but let's say I'm going to add my son to the deed. I put him on the deed to that real estate with me. When I die, it becomes his real estate automatically. He's a joint tenant. He has a right of survivorship, so it transfers to him. So that does not distribute under my will. It's a direct transfer to him on death. The risk with that is that when you transfer real estate that way, my son now steps in my tax shoes, so to speak. So my son receives what we call a tax basis in the property, which is what I paid for it. For example, let's say that I paid $50,000 for that real estate, and I bought it 30 years ago, and it's worth $500,000 today. Well, now I've had that $450,000 of gain, let's say, right? Increased in value. That gain is now my son's problem. He has to pay my capital gains tax. Whereas if my son received that asset under my will or under my trust, he does not pay my capital gains tax. He gets a date of death value for it, the $500,000, let's say, and he avoids my capital gains tax. So I have many people who come to me to say, hey, I want to add my children to the deed. I heard that's the easiest way. Well, it is easy, but it has problems. The other problem is if my son owns it with me while I'm living, his creditors can touch that asset. So if he has a judgment in it against him or some creditor is chasing him, they can receive that entire asset, not just his half. They could sell that property to pay their debt. So titling assets in the name of heirs is not always the best technique. There's a direct transfer on death. That's where you have a beneficiary named. This would be like a life insurance policy or your Nimio account. And there's no problem with that. Direct transfers, pay on death transfers, transfer on death transfers. We use those all the time. And those are good techniques to use. I do not discourage those, and I encourage people to use that. The only issue with that is you don't have any control of that asset, and it's going to go directly to that pay on death designee or beneficiary on death. So a will is another way of transferring. We mentioned this before, and that's what we call the probate processes involved with transferring assets under a will. And your personal representative is the person who would open the estate in the courthouse and follow the probate process for 6 to 9 months, and then ultimately distribute those assets. Trust is another way to distribute assets. This is a way to do it without probate. So that's why I mentioned earlier, it's what we call a private probate, so to speak. It does the same thing a will does, but it does it a little differently. We'll focus on that later, a little bit later on. Any questions? All right, you guys are too talkative now, okay? Okay, so the non-probate transfers, as I mentioned, by adding somebody to title or having pay on death. Again, you can avoid probate with that. Does that mean no problem? I mean, maybe it's no problem if your beneficiaries are perhaps responsible financially or old enough to receive the money, then it's no problem. But maybe you don't want them to receive that asset all at once. If you have money in an investment account, maybe you don't want your children to receive all that money. So it is convenient, but again, you have no control from the grave, okay? So if you want control from the grave, then you cannot have a pay on death designee. You need to control it under a will or under a trust. So the direct transfers, again, we use that technique sometimes for insurance, retirement benefits, the 401k, with an IRA account or an annuity, we use those direct transfers. But as I mentioned, They can be risky because you don't have any control from the grave, and that beneficiary is going to receive the money all at once. There's another kind of direct transfer, which is kind of a neat technique. Neat technique. It's hard to say that. That's a life estate deed. I don't know if anybody's heard of that before. But a life estate deed is a deed where you deed the property to yourself for your lifetime, and then upon death, the asset transfers to the beneficiaries or named legatees in that deed. We call them a legatee. So, for example, I have that piece of property. I could deed that I mentioned with my son. I could deed that. I could change the deed instead of me now owning it. I change the deed that says I own it during my lifetime. And upon my natural death, whatever that means, we just use that term. I think it just means death. But upon my natural death, it transfers to my son. So he gets the property on death, and he also gets to get that stepped up tax basis I mentioned. So it gives him the same benefit, but he doesn't have to pay that capital gains tax. So life estate deeds were really popular a couple hundred years ago, and then they kind of fell out of favor. They were very popular, like in the 50s to 60s, perhaps, and fell out of favor. And they're kind of popular again. So we we create them from time to time. They're a little bit tricky because there are two kinds of life estate deeds, and one is a life estate deed we call with powers, and the other is without powers. What are powers, right? I know you all want to know. It's a burning question. See, you all are curious about that. Anyway, so what powers are is the power that I would retain to sell the property during my lifetime or mortgage it. So if I create a life estate deed with powers, it means that I still have control over it. I can sell it, I can mortgage it, I can rent it. If I say without powers, then that effectively transfers the gift when I sign the deed. It's really my son's, and I just have a right to live there. So I don't have any right to sell it or mortgage it when I created life estate deed without powers. And it's kind of interesting. I have a case right now with somebody in Frederick County whose mother created a life estate deed for her. And she has a number of siblings, and she's older now. But the life estate deed is not very artfully drafted. And the attorney who created that life estate deed about 20 years ago kind of messed it up, because what the life estate deed says is that the person has only the powers specified in the deed, and the powers that it says that they have is the power to lease the property. So they don't have the power to sell it. They don't have the power to mortgage it. They can only rent it out. And they want to try to sell it now, this person does, um, because they actually need to move into like an assisted living facility. But they don't have the right to sell it because the powers are very limited in their life estate. And the unfortunate circumstance is this person does not get along with their siblings. Their siblings are the ones who are the beneficiaries of the life estate deed. So she doesn't get along with her siblings. They will not let her sell the property now. And she's kind of in a difficult situation. Is going to have to go on some public assistance in order to get into a facility. So if you create a life estate deed, you want to make sure the attorney who's drafting it is doing what you want with that deed. All right, so here's a summary of our distribution methods. Again, you can have that direct transfer, which is the pay on death, transfer on death, jointly titled assets. Again, that's very easy to do, but you don't have any protection. A will offers protection, and so does a trust. So what are we trying to protect people from, right? Well, we want to protect you from the court systems. You don't want to die intestate. So we want you to have a will or a trust in place. So that protects you from the court system. But you also may want to protect the heirs from themselves. And this is that concept of making sure your beneficiary or heir is financially responsible and is going to be responsible with that money if they receive it in a lump sum. If you don't want them to receive it in a lump sum and you want them to receive it over time, or perhaps when they're older, that's where you use a will or a trust. So if you have a will or a trust, then you can obviously decide when you want your assets distributed. Let's pretend that I'm married and I have two children, which is all true about me. Um, let's say one of my children or one child's completed college, but my other child is not, which is not true, but let's just pretend. Do I want these transfers to go immediately to my children, or do I want them to be distributed over time? I want them to be distributed over time. I have many kind of war stories that I could tell you where I have been involved in estates where children of certain ages have received money way too early, and the money just gets squandered and spent. Um, and it just happens all the time. No matter what everybody's best intent is, when somebody is a younger person, a young adult, again, they're adults at 18, most people are not financially responsible to really save the money and not spend it and save it for a rainy day, so to speak. So, a will is one way we can protect the heirs from themselves. Again, that goes through that probate process. Takes about 6 to 9 months, usually not too much longer than that, although it can. And I can have a will with a trust in it. So I can have a will that says I want my assets to go to my wife first, but if my wife is deceased, then it goes to my children. But if my children get it under a trust. So we call that a trust under a will or a trust in a will. So my personal representative would go through that probate process. Normally with probate, you have to hire an attorney to help you with something with the probate, help you out with the documents and that process. Obviously, you're going to pay for that attorney. And probate is a public process. I mean, you can look at estates online. Right now, you can't access estate records online. You can just look at what's happening in the state. But I think soon those records will be available. And a lot of people don't like that today with our society being so open. A lot of people don't want their financial information or their financial affairs available to the public. So they don't, a lot of people that I meet with don't want a will for that reason. Again, when we use a trust, it's a private process and nobody has the right to see that trust. So probate, we kind of mentioned this slide already. Um, the legal term of probate is to prove the validity of a will. And the court looks at the will and makes sure it's executed correctly, make sure it's witnessed correctly. And then the court requires the personal representative to post a bond to make sure they fulfill their duties. And again, that process takes about 6 to 9 months. It is the most traditional method of dispersing assets on death, but again, it's public and it's also not the most practical or cost effective today. And that's why a lot of people are using trusts today. So with a trust, again, this is a testamentary distribution mechanism or instrument. It distributes assets to your heirs on death. It does the same thing a will does on the death of the signer, but it does it without probate. And there's no waiting period, no 6 to 9 month waiting period. You don't have to open an estate, so you don't have to pay any probate fees to the court system. And you may want to consult with your heirs, or your family may need to consult with a lawyer, but the attorney's fees are going to be very nominal. They're not going to be the kind of attorney's fees that would be involved with an estate. Again, it's private. Nobody sees what assets I owned or who I owed money to. There are no court filings when you have a trust. Okay. The most common type of trust is called a revocable trust. And that's a trust that is what it says, revocable, modifiable, amendable. You can change it at any time. And 99% of the trusts I create are revocable. Irrevocable is a trust that cannot be modified or changed, and it is set in stone when I sign it. And we used to use irrevocable trusts for a lot of tax planning. When the estate tax thresholds were much lower, we would create irrevocable trusts, which essentially transfer the assets at that time, but they're held in trust. and they take those assets outside of a federal estate tax equation. We'll talk about federal estate tax in a moment, but we're not using irrevocable trusts as commonly as we used to, because now you can die with essentially $11 million and not pay estate tax. So we don't need them for tax reasons very often. So we have very wealthy clients, so they're not that favorable anymore. So with the trust, we have a few elements in the trust. Um, we'll talk about some of these elements because you all may have seen a will, but you may not have seen a trust. And it has some different language in it. The person who owns the trust is the person who creates it. We call that person the grantor or the trustor. That would be myself. If I create a trust and I'm the grantor of the trust, I'm establishing the trust. Okay. We have a trustee. That's somebody who can be like an intermediary between myself and my assets. So I'm actually the trustee during my lifetime. And when I die, my successor trustee steps in. So what does that sound like, that successor trustee? It sounds sort of like a personal representative, right? Has the same kind of role, but we don't call them a personal representative when they're in a trust. They're called a successor trustee or an alternate trustee. And that's the person who can sign for the trust, transfer assets in and out of the trust. Okay. Beneficiaries, who are those? Those are the people who receive my assets, right? So that's going to be my heirs, my family members. Just like my will has beneficiaries, my trust has beneficiaries as well. And then we have assets that we need to transfer into the trust. So what my trust documents essentially say is I'm transferring my real property into the trust and I'm transferring my personal property into the trust so that my trust controls those assets when I die. We actually create deeds for the real estate when we do this. So we record a new deed in the courthouse, and it's a deed from myself to myself as trustee. I know that sounds odd, but it would be from Doug Thornton to Doug Thornton, trustee of the Doug Thornton Trust. Um, and then when I die, my successor trustee just has to produce the trust document to show that they are the correct successor trustee. They can take control of my trust assets. They can then sell the real estate and distribute it to the beneficiaries named in my trust. If we do a trust for clients, we also give you a basic will. I know that might sound counterintuitive, but wait a minute, why do I need a will if I have a trust, right? Well, the trust is that master distribution mechanism. The trust is what's going to distribute the assets. But we give you this basic pour over will. The concept is a pitcher pouring water into a glass. And so any assets that I die without having them in my trust or named in my trust are going to pour into my trust when I die, AKA pour over will. Some attorneys don't give you that will, and that's really malpractice if they don't. They really need to give you that will. It's kind of a belt, whereas your trust are your suspenders. So you have a belt and suspenders, so to speak. So with the trust, you have total control of your assets while you're living. They're your assets. I can sell that piece of real estate that I put in my trust. I can mortgage it. I can do anything I want with it as though it's mine. So think of the trust kind of like a backpack that's on your back all the time. You're kind of carrying it around with you, and your assets are in that trust. I can choose who's going to be in charge when I die. That's that successor trustee. And again, they're going to take control of the assets when I die. Again, they have a role very similar to the personal representative. They don't have any authority until I die. So a lot of people think with a trust, I don't have any control of my assets while I'm living, and that's not true. You have total control over them. They're your assets. The trust lets you spend them down to zero if you want, add new assets to the trust, do whatever you want. Um, again, the trust can have that same distribution plan as a will. It can say who receives them. I can give the assets to my wife and then to my children, but it's just a much quicker, faster, and efficient process. So back to that scenario where I have a spouse, a wife, and two children, let's say. Let's say my spouse is deceased and my two children are going to receive my assets. So here's a sample trust distribution plan. I have a son and a daughter. My trust can say that they get one third of the balance at a certain age. I put 25. They get another third at 30 and the last third at age 35. Trust typically says they can have access to the money prior to those ages as my successor trustee determines in their sole discretion. So what does that mean? That means they have a lot of power and control over that money. My trustee does have to let the children have access to it for what we call health, education, college, grad school, etc., and general maintenance expenses. But the trustee doesn't have to give the children the money if they just want to go out and buy a Corvette or something like that. These are just samples or examples. I have some people who give the children everything at age 21, which I don't necessarily encourage. I still think that's a little young. But again, with a trust, you have total flexibility and you can decide at what age and when you want your children to receive the money. So with a trust, we need to fund it. Funding of a trust is a mechanism or a process, again, where we transfer assets into the trust. We don't always put your retirement into the trust. Your retirement account, let's say your 401k or an IRA, sometimes we don't put that in the trust for tax reasons. Because if it goes into the trust can't roll it over into a continuing pre-tax asset, and the trust pays the income tax on it all at once at something called the fiduciary income tax rate. Um, that's a rate the IRS determines, and that's normally a much higher income tax rate than an individual would pay. So we don't always put retirement assets in the trust. We can talk about them if we meet and we go over what are the advantages and disadvantages of that. Insurance proceeds, sometimes we do, but not always. We might want those in the trust so they can be distributed over time and you can have control. We usually always put your investment accounts into the trust and your bank accounts. And again, we would deed your real property interests by deeds and transfer those into the trusts, into the trust, excuse me. There's some other specialty trusts I'll mention briefly. One's called an irrevocable life insurance trust, or what we call an ILIT, ILIT. That's a trust where you can take a life insurance policy and make it have its own trust. When you die, that life insurance goes into the trust, and it's controlled by the trust, and distributions are made under that trust. And we used to use these quite often when the federal estate tax thresholds were much lower. By creating the ILIT, that effectively takes the asset out of your taxable federal estate. So back in the older days, when your taxable estate was anything over $600,000, it was sometimes easy to get to that number, and we would create these specialty trusts so that it was not included in your estate for estate tax purposes. They're not as common anymore. I still do them sometimes for clients who want perhaps somebody to receive just a trickle of money or some money over time under the ILIT. Um, and we do create them from time to time. The other is the Special Needs Trust, and that's a trust that provides benefits for somebody who may be receiving government assistance for a special need. And what these trusts do is they distribute very small amounts of money to the beneficiary so that the distributions out of the trust don't disqualify that person from receiving those federal benefits, like disability benefits. Um, Federal estate tax, we touched on this briefly. I'll mention it now. A while ago, that threshold was $600,000, and it was pretty easy to get to that number. And over the years, that number's gone up. It went to $1 million, and then it was scheduled to go back down to $600,000. But in the last 4 to 5 years, Congress got pretty smart about this. Um, this is something that both Republicans and Democrats don't like. Nobody likes estate tax. They came to some agreement. Now the exemption is $11.58 million. So you can die with that much money without paying any federal estate tax at all now. Most of my clients don't have any estate tax issues. Maryland also has an estate tax. Maryland has a lower amount right now, so it's anything over 5.49 million. Is the Maryland estate tax rate, and that's a flat rate of 16%. Maryland does have another tax that I'll mention. It's called an inheritance tax, and that's a different kind of tax. What that is, it's a tax on people that are what we call collateral heirs. If it's somebody that's an immediate family member, like a lineal descendant, like a child, a grandchild, a parent, and also 1 degree out to a sibling, they're exempt. But if it's, say, an aunt or an uncle or a cousin that are receiving your assets, they have to pay this collateral tax in Maryland, which is 10%. That's what the tax is. So
And I guess that would just be if it is in the estate, not necessarily if it was in a trust or.
So that's a great question. Not true. So
Okay.
you're, the state got a little tricky about that. So what they did was they make everybody, even with a trust, file something called an information report. And an information report is something where you report assets that are distributed under a trust or jointly held with somebody who's not one of these lineal descendants. So if it's an aunt, an uncle, or somebody like that, you as the successor trustee are bound by law to report that and pay the tax on that 10% tax on it.
So what about direct transfers then, if it was a POD kind of situation?
Same thing. Direct transfers are still, these are good questions. They're subject to that tax.
Okay.
In fact, there's a certification in that form that has the decedent, the person who died, made any transfers within 3 years of death to any of these people. So they can go back for 3 years to get, again, to transfers that are people that are outside that exemption window.
And that would include, I guess that would include like if you wanted to seed money to a charity or something like that.
So charities are exempt. Wow, you have a great question there. If they're tax exempt entities, then they are exempt.
Okay, right, that makes sense.
Like a church or something like that, they are exempt from that tax.
Okay.
If they're not a tax exempt entity and you just want to give it to some business that you like, they do have to pay the tax on it. So let's talk about some lifetime planning. I'll call these the legal seatbelts of life. These are documents that everybody should have in place so that somebody can manage your financial affairs or your medical affairs. Being married to somebody, having a spouse does not grant that spouse the right to legally bind you. Okay. My wife can't sign for me just because she's married to me, and I can't sign for her just because I'm married, because we're married. So we need to designate somebody to make these decisions with lifetime documents. So the first document is what we call a durable general power of attorney. Many of you have seen these working at Nimio. That's a document that appoints an agent to make these kinds of decisions, non-health decisions, financial decisions, business decisions. They can file a lawsuit on my behalf with the power of attorney, things like that. We also have a healthcare power of attorney, and in Maryland, we have a special name for that document. It's called an advanced directive for healthcare. And these are important because without the durable power of attorney, if my wife, say, needed to sell our home, she would have to go to court to be appointed as my legal guardian. And the guardianship process is very costly. The least expensive one I've been involved with is in the $5,000 to $7,000 range, let's say, of legal fees, because my wife has to hire an attorney to help her. There's an attorney appointed to represent me, and then the court is usually going to appoint an attorney in that role. They might appoint my wife, but if there's another attorney involved, especially let's say I'm not married, then now we have three lawyers getting paid for that guardianship process, which is pretty expensive. So you can avoid all that with this durable general power of attorney. So it's almost more important than a will, right? Remember, if you die without a will, you die intestate. It's not the best thing to do, but it's not the end of the world. Whereas if I become mentally disabled and I can't sign for myself, then I need a guardian appointed. So that's an expensive process. So again, this durable general power of attorney um, covers anything that deal with your assets or your financial affairs. Um, Maryland has a statutory form for this, and if you use our statutory form in Maryland, our law says that every financial institution and business and person in Maryland has to honor it. Um, and we often use that statutory form always now when we create powers of attorney for people. That's what we call a general power of attorney. There's something called a limited power of attorney. I'll mention that briefly. That's a power of attorney where I give somebody authority to act for me for a limited or like one purpose. Perhaps I'm going to be out of the country and I want my wife to be able to sell the real estate. So I give her a limited power of attorney just to giving her authority to sell that real property or real estate. But when we do estate planning, we're talking about general powers of attorney. That's what we use. The Advanced Directive for Healthcare is a document where I can make healthcare decisions on my own. That's what the document says. So as long as I'm able to make these healthcare decisions, um, I can make them and my agent does not make them. But if I can't make decisions, then my agent can make basic decisions for me. That's what kind of we call Part A of this document says. Part B of the document is where I set out instructions for my medical care for my end stage of life. And that's where, and a lot of people say, oh, I'm giving my wife or somebody the ability to pull the plug. Not necessarily true. I'm making that decision in the document. I'm making the decision now in advance of the need for the care, of the kind of care I want. So we provide both of these documents, the power of attorney and the advanced directive for healthcare, when we create state plans. So this is kind of a little matrix I created. So if you want to protect your financial affairs and financial access um, while you're living, you should have a power of attorney in place. If you don't, then you could have an attorney appointed by the court as your guardian. The same with health issues. You should have an advanced directive for health care. Again, without that, if you're not married and let's say you don't have children, then I could have an attorney appointed by the court in this role to make those healthcare decisions, which is kind of crazy. We want to protect your assets, your insurance, and the other um, financial matters or affairs that you have. Do that with a will or a trust. Again, you don't necessarily want to die intestate. It's not the end of the world, but it's something you should avoid. If you die intestate, then you can name a guardian. You can name who's going to be in charge of your estate, who's going to be in charge of your children's money, and you can have control. Without that planning, then you lack all of those controls. I think that's it.